It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
That's right. We are live here in the WTAN studio with FLA Law live on the radio. My name is Jacqueline Bryant. I am here with my partner, Brian Caulfield. Hi, Brian.
How are you, Jacqueline? The law office is open. We're here to answer questions for the next 1 hour.
Exactly. This is our live legal call-in talk show. As you know, hopefully you are a frequent listener. We are here on the air every Tuesday night at 5 o'clock on your drive home from work for you to call in with your legal questions tonight. As you know, we are personal injury attorneys with the law firm of Perenich, Caulfield, Avril, and Noyes. You can find us at voiceoftheinjured.com. And we are here every Tuesday night answering your legal questions. Of course, we specialize in personal injury, so that's our forte, and that's kind of what we're going to be touching on tonight, as we usually do. But we will have guests throughout the months of various different topics. And of course, we're willing to take a stab at anything you throw at us tonight and see if we can point you in the right direction. I will let you know at the end of the month, we've got a bankruptcy attorney coming in. We've also got a family law attorney coming in. So I encourage you to listen to us every Tuesday night at 5 because we've got some great shows lined up for you all. So I'm going to give you the contact information so that you know how to reach us tonight in the studio for Brian and I. The number to call in is 727-441-3000. Again, that's 727-441-3000. That's how you're going to call in tonight to get your questions asked over the air here at the studio while we're here live taking your questions. Now, if you don't want to hear yourself on the radio, you prefer to drop a comment or a chat in the chat box, then you may know that we are streaming live right now on Facebook. Our Facebook page is Perenich, Caulfield, Avril, and Noyes Injury Lawyers. Type that in your search box in Facebook. You should be able to find us live. We're on the air. You can see us in the studio right now. Perenich is spelled Perenich. Type that in. You should be able to find us. If you don't have Facebook, but you have YouTube, you should be able to find us the same exact way. Type in Perenich, Caulfield, Avril, and Noyes Injury Lawyers. We are also streaming live on YouTube as well. So with that being said, I want to obviously jump into our topic tonight. We are touching on what I like to call FAQs, frequently asked questions. I did check our website. I know a lot of websites these days have that like FAQ page, but I don't think we have one. But if we did, it'd probably be an extremely long list of questions. So I obviously can't go over every possible question, but only some of the ones that I think we probably hear a whole lot, Brian, when we are, meeting with new clients and discussing, their potential cases. I'm sure the ones that I throw out to you tonight are ones that you've probably answered a lot over the years. So with that being said, I do want to give Brian just a chance to introduce himself. You probably heard him before on the air, but you may not know, if you're a new listener, who he is and what he does at our firm, and that he's board certified. So go ahead, Brian.
Yeah, thank you, Jacqueline. I have been with the law firm actually since before I became a lawyer. I actually started off as a law clerk back in 1987. Became a lawyer in 1988 and became board certified 8 years later, so in 1996. And I have been board certified continuously since 1996, all the way up to now. You have to recertify every 5 years.
Yes.
And board certified lawyers, for those folks that are out there, have a different level of skill and experience. And it's really the only objectively measurable standard that one can look at as a consumer to try to get an idea of how experienced their lawyer is, because you can't take a board certification exam unless you've had 15 jury trials, and you have to go through a kind of a blind peer review process. And if you pass all those things, you're then given permission to take the board certification exam. And of course, you have to pass that.
Exactly.
And then,
which is no small feat.
No small feat. Then you've got to recertify every 5 years by trying at least 2 cases. Essentially, it's just letting the public know that when you call yourself a trial lawyer, you really can prove that you have been. So certainly it's a good thing for consumers to know. And that was important to me in my career. So when I graduated from Stetson University College of Law, I was on the trial team there.
Go Hatters.
So I was, I was very intent on learning while I was in school, learning that craft of being a trial lawyer, and then putting it into execution as soon as I became a lawyer.
Awesome. Well, that is obviously a big accomplishment in my book. Trials don't always come easy in this realm, but that's something that I've talked with Lori about in our office, who's also board certified trial lawyer. And we may get into a little bit of trial topics today as we go through some of these frequently asked questions. But before we do that, I wanted to kind of just jump into kind of what we may see the most is our auto claims, right? That's kind of our, wheelhouse when it comes to the personal injury world. Auto claims are a big part of what we do. So one question that I want to jump right into, I see a lot, is the traffic ticket, right? I see a lot of clients always asking us, well, hey, the other guy got a ticket. Why is the defense lawyer not admitting liability? Doesn't that resolve this whole dispute about who caused the accident? Why does that not resolve the liability dispute, Brian?
Well, because shockingly to our clients, and actually even to me when I was a lawyer coming out of school, people are shocked to realize that the actual law in Florida is who got the ticket, or whether any ticket was issued whatsoever is not admissible in court in a civil action for personal injury. So like you said, I have plenty of cases where the client comes in and says, oh, this is an open and shut case. Yeah. Mm-hmm. I know there's no witnesses, but the police officer gave them the citation for running the red light. Mm-hmm. And then we have to go through and talk to them about, well, why that doesn't, it certainly helps for the insurance claim purpose, but in terms of the actual jury trial to try to get you compensated for your injuries, you can see people do a complete 180 with their story, which brings us to another thing that people are shocked to learn, and that is the accident report privilege.
Oh, yeah. You anticipated my next question.
Yeah, well, the accident report privilege is something in Florida. Florida has a statute 316.066, so you can take a look at it. And basically what it does is it sets up a privilege. It puts a responsibility on you as a driver to report an accident and also to report information about the accident, who was involved, how it happened. And they do that for reporting and statistical purposes so that, the state government can gather very accurate data on the number of crashes, the types of crashes, the location of crashes, because, maybe they want to make some changes in a roadway.
Right.
But unfortunately, what people don't understand is that accident report privilege prevents you or the investigating officer from testifying to anything that the other driver said. Right. And one of my longest running cases I have right now, is a case where someone after an accident confessed to the police officer that they took somebody else's prescription drugs that they didn't have a prescription for. And that's all over the accident report. But then when it came time to actually litigate in this case, it was a wrongful death case, that person denied that they had taken, any medication. And I was unable to utilize that statement. So people are shocked when they hear that, and they'll come into our office and say, well, the defendant admitted that they were at fault to me.
Yeah, they got the ticket.
Because they were in a conversation with me and the police officer, and they admitted they were at fault. Well, if the police officer was part of that conversation, you're not going to be able to repeat it. If they came to you and there was no police officer and admitted fault, that's a different question. But the accident report privilege basically is designed so that people will cooperate with law enforcement. Right. And in exchange, they get a privilege so that what they said to law enforcement can't be used against them later. And that's probably the number 2 shocker about personal injury law.
Absolutely. And I think another question that I wanted to build on that. Now, isn't it true that privilege does not necessarily apply to witnesses, right?
That's correct. It doesn't.
So when you have a witness who saw something and maybe they shared what they saw to the police officer, their name is on the police report, and they can testify as to who was at fault or not, that privilege would not preclude, they their testimony, right?
Right.
So I think that's a good thing to know. So a lot of people, they unfortunately don't always talk to the witnesses, don't get their numbers. There was somebody there, but I didn't. You should always ask their name, get their phone number, do whatever you can to try to get those witnesses. But if they are on the police report, that's good for us because we can at least track them down.
Absolutely. As you know, in this business, witnesses are key.
Oh, yeah.
Because, I've been doing this now for 35 years, and I've had plenty of rear-end collisions that you think are open and shut cases, and so does your client. And then once the lawsuit is filed, all of a sudden the person that caused the rear-end collision has a new story about how the accident happened.
Oh, for sure.
They claim that, well, the vehicle in front of me made a sudden and unexpected stop, and that's why I ran into the vehicle. Mm-hmm. Even though, the truth of the matter is you've been sitting at a red light for 60 seconds before you were hit. So, witnesses are key. And one of the things that I've seen in the development of my practice as I've worked, a 35-year career, one of the biggest things has been something that has been big on every other front in society, and that is surveillance cameras.
Oh, yeah.
Surveillance cameras are absolutely huge. I mean, obviously, we live in, you might say, a decade in which, surveillance video has shown so much. Whether it's,
even more so now, for
certain,
sure.
Famous cases where law enforcement was found to have done wrong and never would have known about it, but for surveillance video. But that same thing goes with regards to civil cases. I've had cases where, but for the fact that we were able to find video from a trailer park adjacent to US 19, I never would have been able to prove the cause of an accident.
Amazing.
Had another one. It was a motorcycle accident, and unfortunately, the motorcyclist was killed. So the motorcyclist can't be there to tell a jury what the other driver did to violate their right-of-way.
Exactly.
And in fact, the statement they made to law enforcement was completely untrue, as was shown later when there was a U-Haul business right near the scene of the accident, and they caught the whole accident on camera. And so, that's huge. And obviously, one of the other things you and I see quite a bit is the old computer electronics that are inside of the automobile, so-called black boxes.
Black box. Mm-hmm.
So those are really kind of big developments that have really affected our practice over the last decade, for sure.
Okay, so that's actually a really great point. And you mentioned about the reporting of the accident when we touched on the accident report. So I think that brings me to another good question that people tend to get wrapped up about when they come into us right after a car accident. And they're like, I have to report this to my own auto insurance. Why would I do that when I'm not at fault? Isn't that going to cause my rates to go up?
Yeah, isn't that a typical response? I know, I've had people come in, and despite the fact that we asked them to bring in their own insurance information, they come in and they say, well, no, I didn't bring it with me because I don't want to make a claim on my insurance.
Exactly.
It's going to cause my rates to go up. And why, Mr. Lawyer, would you be wanting to ask me to make a claim on my own insurance? I thought you're on my side and I don't want my rates to go up. Well, we have to explain to them, don't we, that Florida is a no-fault state.
Right.
And the first $10,000 in medical bills and lost wages goes to your own company without regard to the fact that the other driver is clearly at fault.
Exactly.
So you've got to make the claim. And of course, as you well know, the reason why you have to report it is because your policy has a duty, a written duty right within the policy that says you need to report the accident as soon as is reasonably practicable is typically the language that's utilized. But essentially, it's to let the company know that there's a claim coming and gives them a chance to investigate that claim the way they see fit to investigate it. So it is one of your duties on your policy. And if you fail to follow that duty, you can lose the coverage that you paid for.
Right. And I feel like we've been stressing this for years. And I just recently got dinged on a case where clients came to me a couple weeks after the accident and they hadn't treated in the first 14 days. And I'm like, I feel like we've hammered this home so many times. But if not, if you're listening out there, you must treat within the first 14 days in order to be and even entitled to those benefits that Brian just talked about, those no-fault benefits that you have a duty to report to your insurance company. You may not even get if you don't treat within the first 14 days.
Yeah, that's really an unfortunate law that was passed. Just one of the many laws that unfortunately had a good intent behind it, but the actual operation of it, really, really is unfair to someone that hopes they're going to get better, so they don't treat. And then when they finally a week later are hurting,
ibuprofen,
they make an appointment. The appointment can't be had for another week or so. So before you know it, they're strolling into their doctor's office on day 15, and it's
That's
too
exactly
late.
Right. I think mine kind of fell around the Hurricane Idalia, and offices were closed, and they couldn't get in, and it was one of those situations where it was just unfortunate that they just couldn't get in right away, and they thought they'd get better, like you said, and now this law has kind of impacted their benefits and what they would have been entitled to. And it was actually a few of them, so sad, but we're going to obviously still pursue the case and we move right along. Now, with that being said, tying into my insurance and why I have to report it to my insurance, I wanted to touch on health insurance as well, because I get that question. I think it probably changes a bit now with the tort reform that was recently passed in March. But a lot of people ask, should I use my own health insurance? And, I really don't want to get my own health insurance involved. I've got a high deductible. There's co-pays. That's a lot of out-of-pockets for me. Brian, should I be using my health insurance for this personal injury case?
I always have the client, utilize the health insurance and coordinate the benefits because, in the end, you don't know exactly what's going to happen in the case against the at-fault party. And so if you have a source of insurance that you're paying for, of course, your health insurance is not going to jump in and pay right from dollar one.
Exactly.
Because your health insurance is not considered a primary payer. They want to see that you utilize your personal injury no-fault benefits. In other words, the required auto insurance in Florida, the PIP or no fault, that $10,000 fund of money to pay medical bills and lost wages, your health insurance is not going to pay until and unless you prove to them that that's exhausted. They're considered like a secondary payer. But it is, it is very important to coordinate those benefits. I'm working on a case right now out of Lakeland where someone was hit by a bus. One of the bus companies owned by Polk County, and very, very serious injury happened in the parking lot to the city library. Turns out the accident was on video, which is very good because my
those
client,
buses have videos everywhere too.
Yeah, so they have video inside of the bus, and then after I took the case in, I went immediately to the library to investigate, and they had 4 cameras on the outside of the building.
Nice.
But the point of that is she had very, very serious injuries, spent, a couple of weeks in the hospital and then on to a rehab hospital. And the typical auto insurance policy that people have here in Florida, the only mandatory requirement is that they have $10,000 in coverage.
Exactly.
And I can assure you that $10,000 was spent, within the first few hours of her arriving at the hospital because they had to do so many different scans upon her. And so her bills are going to be just monstrous. So,
absolutely.
The PIP or no fault coverage is not going to do the trick. And then one of the other quirks in the law is because she was hit by a vehicle that's owned by either a city, a county, the state of Florida or any town in Florida, they have this law that caps damages.
Absolutely.
At $200,000.
A lot of people don't realize that. Yeah.
Her bills alone are probably going to be $600,000.
Exactly. Wow. And so she has to use her health insurance in that type of a scenario. And that's why I think a lot of people don't understand. It's like, well, my health insurance is not responsible here. It's this other driver. But I think even before the tort reform, I think even more so now, but even before the tort reform, I think the clients will come out a bit better going through that process. Once you coordinate the benefits, as you said, I think can make a better recovery for our clients when they use their health insurance, as opposed to having these large outstanding balances that we have to negotiate.
Yeah, I agree. I mean, it certainly, works out a lot better in the end. It puts more net money in the client's pocket. And that's one of the jobs that your attorney has, is to coordinate the benefits so that it's best for you.
Exactly. So when in doubt, use your health insurance after the PIP. So I have another question about auto before we take a quick break. But before we do that, of course, we are still here live in the studio. So your questions can come in at any time. Don't think that because Brian and I are having a good conversation here that you can't interrupt us. We want you to. The number here is 727-441-3000. Please call in, give us a call, ask a question. As always, we are on Facebook Live as well and can answer your questions in the chat. I do see we have a few viewers online. Thanks for watching. So before we take a break, I wanted to ask you about a question I tend to get all the time when there's a work comp auto claim. So this person is injured in a car accident while in the course and scope of their employment. And so there's work comp benefits, and then there's auto. There's the PIP that we just talked about. And a lot of people are really confused about, do I use one or the other? Do I have both claims? How do you tend to explain that?
Yeah, well, I mean, the good news is you have both claims. So if you are involved in a car accident while you're at work in the course and scope of your employment, it actually opens up more benefits for you than if you were not in the course and scope of your employment. Of course, all of that needs to be managed because the work comp law here in Florida, very restrictive, really controls, the medical care, almost with an iron fist. And you have to get care from a doctor that they approve. And unfortunately, those types of physicians that they're willing to approve might not be the kind of physician that you want to have treating you for the long term. And so,
I would not disagree.
Those cases require a great deal of care and consideration as to how to coordinate those benefits so that it is best. But, I think in general, the good news is there's a big source of payment of medical bills. So when you have those really, really large cases, when people are, under the course and scope of their employment, having that kind of potential to get lifetime, medical bills paid through workers' comp is certainly helpful.
And I think the key with that is what I usually tell people when they come to us with that type of case is that you came to the right firm, because we do both. We handle workman's comp and we handle the auto case. And so you're basically in a position to have one attorney manage that properly. And what I've seen in other cases, it's one attorney does the work comp and they farm out the other part or vice versa. And it's a little harder to manage when you've got two different lawyers and trying to figure out, where am I going to settle the work comp case? And it's just harder, I think. So with us at Perenich, Caulfield, Avril, Noyes, you can have an attorney who is able and capable, experienced in handling both claims simultaneously and making sure you get all the benefits that you're entitled to in both claims, right?
Yeah, that's the way I feel about it as well. So, you can really work to maximize the net recovery to your client. And it's an easier thing to do if you're in control of both of those cases.
Exactly. So the lines are open, folks. We are going to take just a brief commercial break. But as you know, the number here is 441-3000. Again, that's 727-441-3000. Give us a call with your legal questions tonight. We're live on the air until 6 o'clock. We look forward to hearing from you after the break.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Perenich, Caulfield, Avril, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, Call Perenich, Caulfield, Avril, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the Tan Talk Radio Network.
And we are back from the break. You are here with Jacqueline Bryant and Brian Caulfield, partners and attorneys at Perenich, Caulfield, Avril, and Noyes. I hope you've been listening in. You've been getting some really good facts from Brian, what we call the FAQ show, frequently asked questions in the personal injury realm. We're touching on quite a few topics tonight, but I think they're very good because it tends to be some of the questions that we get asked very often when meeting with new clients or just discussing their personal injury cases in general. And of course, you have Brian, who's a board certified civil trial lawyer, who's answering these questions for you tonight. The lines are open. The number is 727-441-3000. Give us a call if you have any questions about the topics that we are touching on tonight. I'm almost done with auto. I've got one more auto question, and then we'll go into some other topics. But like I said, auto is mainly what we do, so it's worth spending some time on. So my last auto question to you, Brian. The driver that hit me does not have any bodily injury coverage. Can't we just take this to court? Don't we just sue them?
Sure. The answer is yes, you could sue them, but what can you get from someone that has no auto insurance and no money? And the true answer is not much.
Right.
Here in Florida, if they have a home, it's homesteaded more than likely, so you won't be able to take that from them. So really, in large part, what you're going to be able to recover from the at-fault driver is really greatly affected by the amount of insurance they have. It's unlikely that they're going to be a very rich person with lots of attachable assets and have no auto insurance coverage. So typically when you get hit by somebody with a $10,000 policy, that person doesn't have a lot of money.
Exactly.
And so if they have no insurance and what you outlined, that is extremely unfortunate. But what people are shocked to learn is they come to our office, and when we find out the other driver had no bodily injury liability coverage, they say, well, I don't understand that. I thought Florida was a mandatory auto insurance state. And I have to explain to them, well, yes, it is.
Not in the way that you think. Yeah.
But it's only mandatory that person have insurance to cover themselves and $10,000 in your property damage.
Exactly.
So it really is a major misnomer, and it sets people up for something that is probably the worst experience I've ever had. And I have it repeatedly during my 35 years as a lawyer. And that is when someone gets seriously injured or a family member is killed and the other driver has little or no coverage. How can people protect themselves, Jacqueline?
This is time for me to stand on my soapbox, right? I have said this time and time again on this show, but it bears repeating. You have to have what's called uninsured motorist coverage or underinsured motorist coverage. UM is what will protect you and your family, your loved ones, when they're involved in a car accident and the other driver doesn't have BI, like the scenario that we're talking about, or they have BI, but it's very low limits and it doesn't, come close to the damages that have been sustained. That's the only way to, truly protect yourself is by carrying that coverage. If you already have BI on your policy, then it's something that you should be carrying, because I don't know if your agents or folks are telling you, but technically you have to reject that coverage when you carry BI. You have to have a waiver in order to not have the UM. And a lot of people sign these things not realizing that they're signing away very important rights. And a lot of times we'll get policies where my client has $100,000 or $300,000 in BI, but no UM.
Yeah, and that's so critical. So what Jacqueline's talking about is when you buy bodily injury coverage, you're buying coverage to protect other people in the unlikely event you're negligent and cause an accident. So people will bring in their policy and say, oh, I looked at my policy and I have $100,000 in coverage. Mm-hmm. Well, no, you have $100,000 to pay to someone else if you caused this accident. But the coverage we were looking for, known as UM, uninsured motorists,
That's the key.
unfortunately, they don't have it. And I don't know how many times it's happened to you, but it's happened literally hundreds of times to me, where when I meet with a client and I explain to them, well, you bought $100,000 in liability, so you would have had to have been offered by law $100,000 in uninsured motorist benefits. Do you know if you have it? No, I'm not really sure. I think I do because I have full coverage. I'm quite sure I do.
Everyone thinks
but I
they
don't have
full
I don't have
coverage.
it, and I know that I didn't sign any document refusing or waiving that coverage. But what happens when we get all the paperwork? There's their signature
There it
on a
is.
document where their agent has talked them into rejecting uninsured motorist coverage. If you don't have uninsured motorist coverage on your auto policy, you have committed the biggest insurance mistake that will affect you and your family in the event of a severe accident. So if you don't remember anything else from the show tonight, the take-home message is buy uninsured motorist coverage. Get your policy out, dust it off, and send it to us.
Pull it up on your phone.
Yeah, pull it up on your phone
apps
from the app and make sure that you have uninsured motorist coverage. And if you do not, you have to add it immediately. It's a low-cost coverage that protects you from the very worst of accidents that we see, the really serious ones where the other driver has some coverage but not enough to fully pay for the damages.
Exactly.
Underinsured motorist coverage allows us to take the amount of coverage that the other side has and then turn back to our own company to get additional funds from that underinsured motorist coverage. So it protects you when the other driver is uninsured.
Right.
But sometimes, almost more importantly, it protects you when the other driver is underinsured.
Right.
So please check your policy. If you have any doubt, you can fax that policy to us, take a picture of it on your cell phone, give us a call and send it to us. We'll look it over for you. But uninsured motorist coverage, people really should be allowed to drive without it. There actually was a period of time here in Florida where whenever you bought liability coverage, you automatically had UM. But guess what? The insurance companies got together with the legislature and said, we don't want to sell this uninsured motorist coverage to everybody.
Right.
We want to give people a way where they can opt out of the coverage. And that was a terrible development in Florida law. And the irony,
to their own detriment.
The irony of it is when that law got passed, allowing people to reject uninsured motorist coverage, I got a flyer from my insurance company hailing, great news. Here's a way to save money on your car insurance. Reject uninsured motorist coverage. And I thought to myself,
drive around unprotected. Yeah.
How incredibly outrageous. Our legislature is supposed to be up there protecting us.
Wow.
And instead, the biggest insurers in the nation are hailing this as a great victory for the consumer, when in fact it's just the opposite.
Yeah. And I think I mentioned how people can kind of pull up their policy on their app, but that has almost become a problem in my opinion, because people now can tinker around with their own policies. They can change their own policy limits and pick their own coverages without really having a clue what they're doing. They're just trying to save money and they want their policy to go down. So they eliminate that coverage. They take that coverage off and, I'll decrease those limits. I'll reject UM. And it's like, oh, now my policy is more affordable, but you just got rid of all the coverages that you needed to protect yourself. So folks, don't do that. If you can, give us a call. Like Brian said, we're happy to review your policy, let you know what coverages are really important. But if you don't remember anything else, like Brian said, UM is the coverage that you need to protect yourselves. And I always tell people that, if you're not sure, just send us a copy. I had a client, and not to talk about anymore, but I had a client who accidentally removed collision coverage from his policy. It was like a brand new car. And sure enough, got in a car accident with a dump truck, and they denied liability. And this vehicle that was practically brand new couldn't be fixed because there was no collision coverage on his policy. He's like, I don't know what I did. I was just doing things in my app, and he didn't have any collision coverage for that accident. So,
yeah, that's not good.
Yeah. So it's very important that you know what you're doing and you know what kind of coverage that you have on your policy. You can't forget about the UM. So that was the UM soapbox, and we'll move on from that conversation. I wanted to touch briefly on premise liability cases as well, because that's also a very big part of our practice. And I feel like we would be remiss if we didn't talk about trip and falls, slip and falls. So if you have a client come into you for a trip and fall case, I think a lot of times there's a misunderstanding as far as what is needed to be proved in terms of liability. So first and foremost, I think we should touch on notice. So people tend to come to me, and I'm sure to you, Brian, as well. I say, well, I tripped or I slipped and I had a fall. And the defense is now they never knew about this dangerous condition, or they didn't know that it was there. And a lot of clients don't seem to understand why that matters. I mean, I was hurt. It was their property. There was something there that caused me to fall. Isn't that enough?
Yeah, you bring up a really good subject, because I was just talking to a client the other day about this, and I had repeated to me the number one myth about premises liability cases. And the daughter, whose mom had suffered a severe injury after falling in a business, repeated what they believed the law to be. And she said to me, well, my mom was hurt on their premises, so they're liable. So people are, if you think that because you were hurt at a business or at a mall, that the place of business that you were hurt at is responsible automatically for your accident, you are incorrect. And Jacqueline, as we know, the law is negligence. You have to prove that the defendant landowner was negligent. And when you talk about notice, there's really two ways that we go about proving that. Number one, actual notice. That is where the defendant admits they had notice of a dangerous condition. Example, true example, by the way. I had a case in which the assistant manager ran up after someone had fallen in a grocery store and said, damn it, I told them about that puddle, meaning he had told his employees.
Perry Mason moment.
Yeah, and so obviously I had what I needed there. But, as you and I well know, typically the defense in these cases is, I didn't know, nobody told me. And under negligence law, you can't be liable unless you were negligent. And in other words, if you're the business owner, you had to have some notice, actual or constructive, that dangerous condition was existing on your premises. So that certainly is something that gets a lot of people. They come into our office and they're convinced because, their uncle from New York told them that whenever you fall at a business, the business is automatically liable. But unfortunately,
cousin Vinny.
Cousin Vinny doesn't get to practice law here in Florida.
Yeah, and I think I remember seeing a video, and I don't know if it was, whose case it was, but I remember seeing a video where a person had come into a store and slipped and fell in an aisle on some sort of liquid. And when the video came about and everyone was able to see it, they noticed that a child had been sitting in the, buggy with their parent and spilled something literally just seconds before that person came behind them and slipped and fell. And so that is kind of the main issue that we're talking about when we're talking about notice. Yeah. And did they have an opportunity to appreciate that this child had, spilled this liquid on the floor,
Yeah, no. So
in that case, they didn't really.
That's a good law school question, right?
Yeah.
So the result of that is good news for the store. They're probably not liable because they didn't have enough time to receive any notice of the dangerous condition and an opportunity to do something about it.
Exactly.
And so if that's the video that you get, you better hope that you can identify whose child it was that spilled that on the floor, and then potentially you've got a homeowner's claim against them.
Send them the letter, right?
Yeah, so it really is interesting. Obviously, as lawyers, we have to take the factual situation and study it, because sometimes the way cases start are not the way they end. Like you could take a case like that and think you have a case against the store, but then after you see video evidence, it turns out, well, hey, if this was some other patron that was just there ahead of you and their child, was allowed to open and be drinking while you're in the store and then spills it, and then that person didn't do anything to clean it up or warn people behind them and just took off,
right?
Then you could have a case there. So certainly that's an interesting example.
Yeah. And so in the converse example where this happens and then you see the store employees walk by it and it's gone 20 minutes, 30 minutes. Everybody's kind of cruising by. I think that's a much better case for notice, right?
Yeah, that absolutely. And so that's, again, the beauty of surveillance video, because, we've all had cases where, but for the surveillance camera, we wouldn't have had the facts, because I don't know how long something was there is, largely fatal to your claim.
Exactly.
Kind of the hallmark of premises liability law is that the defendant landowner had some opportunity to, discover and correct the dangerous condition. And so if no facts exist to prove how long that was there,
you're in trouble.
Then your case is in big trouble. You don't automatically make a recovery because you fell on, the slippery soap that was spilled on the ground or soda that was in the middle of an aisle. You got to have more facts than just there was a foreign substance on the ground.
Exactly. So I think we do have a caller on the line. We have Max from Clearwater. Go ahead with your question, Max. Can you hear us?
I can. Good afternoon or evening, Jacqueline, Brian, and Brian. I was wondering, when you get premise liability insurance, is it only to protect other people on your property, or can you also get it to protect yourself in case you get injured?
That's a great question. I'll let Brian tackle that.
Typically, there isn't any premises liability coverage that you buy to protect yourself in the event of your own injury. That would be more like health insurance that you buy, and that pays your bills no matter how you get hurt, whether you fall off your bike or whether you go to someone else's premises and injure yourself. But premises liability coverage is typically coverage that you buy, and the most typical type of premises liability coverage is homeowners insurance.
Right.
You own a home and you take out a homeowner's policy, and that policy protects other people that come to your house if they end up falling, for example, on your broken sidewalk or slipping on, your mat that you've known, was falling apart and was sticking up. Then your insurance does two things. When that person makes a claim against you, it pays for a lawyer to defend you, and then it has up to a certain amount of money to indemnify, meaning to pay to the person who was injured on your property. And many times there's another coverage on that policy that pays regardless of fault. That's called medical payments coverage. And that can be very helpful in warding off a claim against you. Many times claims are made because people don't step up and agree to pay the bills. And so if you have a fund of money there that if someone comes onto your property and sustains an injury and you have a ready-made fund to be able to reimburse them for the bills, sometimes people won't make a claim against you.
Exactly.
So that's generally the way premises liability insurance works.
That was a great question, Max. Did I answer your question?
It did. Thank you very much, Brian.
All right. Thank you for calling tonight.
Thanks for calling. That leaves the lines open. You can get your calls in. We've got a few more minutes on the air. We've got time to take some more calls. The number is 727-441-3000. That's actually a great question that Max asked, because I remember having to deal with something at my own home, noticing that the material that was used on our front porch patio got really slippery when it was wet. And I thought when we bought the house, I'm like, some delivery driver or somebody's going to come up here and slip and fall. We're going to have a homeowner's insurance claim on our hands. So it's actually a very good question. And I remember looking at, I think it was a personal injury group that I was in, and somebody was kind of vetting a case to see if anybody wanted it. And it was like a wife who, fell in her own home as a result of something that her husband knew needed to be fixed, but didn't fix it. And then she had an injury, and they're like, is there any case here? And we're like, no. Get a divorce, maybe. That's the only claim
because unfortunately, although they've abrogated interspousal tort immunity in Florida, and one spouse can sue another for a tort, the problem is there's unlikely to be any insurance coverage for that particular thing, because that homeowner's policy would say, hey, we don't make liability payments to the named insured's family.
Right.
And that's to avoid collusion.
Right. It's tough. That would be a really, really crafty, a crafty attorney could take that one on, I think, which you've been known to be, right, Brian?
I certainly have had some interesting cases over the years.
And we're going to touch on an interesting case in a second when we get to our current events. But I wanted to ask you another question about premise liability cases that I think is another FAQ, or frequently asked question. So we have a case, let's say we've taken it on now, and the client has photos of this dangerous condition, be it a hole, or maybe it's a broken curb, or rebar sticking out, or something like that. And then it has now been fixed by the property owner or the business. They've corrected it. It no longer exists. And the client thinks that's our smoking gun, right, Brian?
Oh, yeah. I mean, the clients come in and they're super excited because they can say, well, I know it was a dangerous condition and I can prove it because they went out there the next day and filled in the hole. Mm-hmm. And so, that's proof it was a dangerous condition. And unfortunately, we know that, we have to set them down and let them know that post-accident changes made by the defendant are generally excluded from evidence. So that fact is never going to see the light of day in your personal injury trial. That
fancy legal term, subsequent remedial measures.
Yep. And the thought behind it is, look, if we punished a business for making a safety change after an event, if that could be used against them,
right,
then that's going to cause people not to want to correct the dangerous condition until any potential lawsuit arising out of that accident. So, it has certainly, good intentions. The problem sometimes is it can create a proof problem for you because, it's always great. And I absolutely, with the advent of these, cell phones that everybody has,
oh, yeah.
That's one thing, that is so much better now than it was when I started practice 35 years ago. Getting pictures immediately of the dangerous condition that caused your fall. And, obviously you can be helpful to your friends and family. If you happen to be with someone that has sustained an injury that you believe is as a result of someone else's negligence, utilize your cell phone. It's a wonderful tool to preserve evidence. Take video, take, photographs. Mm-hmm. Maybe you could even interview witnesses or interview the defendant themselves on video. So you get admissions from them so that they can't change their story later on. But the cell phone is very powerful for preserving evidence. And that's what it's all about in these cases. So I encourage everybody to, do the best they can to help themselves document their own case. But, even kind of more typical, if you're with someone that suffered an unfortunate accident, do the best you can to help them document. I mean, they're in pain. They're getting attended to by the EMS people. That's the opportunity for you to take photographs to preserve the condition
and their injuries,
and to get the names and addresses of witnesses, and that is so helpful. I've had many cases where, thankfully, a family member was there, and the evidence that the family member was able to bring forward is what cracks the case.
Exactly. And at the risk of sounding like an elder millennial, I was thinking, what did you do before cell phone cameras, Brian?
Yeah,
how did you preserve that? You had to send out the investigator.
Yeah, you send out the investigator, and then you're typically dealing with subsequent remedial measures because by the time the investigator got there, that condition was filled in. And it's very, very difficult to have a jury envision a hole that has already been filled in. So having those actual photographs of the condition, and even better if you're able to utilize measuring, devices, a ruler, yardstick, or whatever to show the size, because inevitably if people go right up to the hole and stick their camera right up to it, you get a out of focus picture
you can't
with
tell the depth,
kind of no scale.
Yeah.
And so it's always a good idea, even if you don't have a ruler with you, then put some common item.
Yes.
Whether,
I've had clients use their keys, credit
keys.
card.
I've had
just don't show the numbers.
Yeah. You can use dollar bills. You can use coins. You can use, kind of another person's cell phone that you can lay down to give an idea of how big it is. But yeah, certainly, you have to be thinking about helping yourself. And the problem with the premises liability accident, or really any accident in which you sustain a severe injury, you're in no condition to think straight and try to preserve evidence and witnesses.
Exactly. That's a great point. So I think that concludes kind of what I want to talk about premise liability, but I wanted to very briefly and quickly touch on med-mal. I don't handle much med-mal, but I know that it's a big part of your practice, and you and Mark Perenich enjoy that area of law. So I wanted to touch on it really quickly because I see this when I do get clients who call me about med-mal cases. They tend to have a similar question when it comes to an incident that has occurred. Let's say it's a surgery. They had a surgery, but it was 3 years ago. And they've had complication after complication. They've had revisions. They've had new surgeries. And they finally discover the original surgeon made a mistake 3 years prior. Do they still have a case, Brian?
Yeah, the odds are not good for them because in general, the medical malpractice statute of limitations, that is the time you have to bring an action for medical malpractice in Florida, is 2 years. Now, that can be extended for up to 4 years by something known as a discovery rule. And that would take probably longer. That we could do a whole show on the discovery rule.
Yeah.
The idea is that you can actually gain more time if you could show that you had no reason whatsoever to know that there was some kind of harm. But that rule is very strictly construed against you. So really the safest thing to do is to think of 2 years. And if you think you get a case, you've got to get to a medical malpractice lawyer to have that lawyer evaluate the case.
Right away.
And the law is such in Florida that you really can't bring a claim for medical malpractice unless the medical malpractice results in very serious permanent injury or death. The cases are just too fabulously expensive.
Oh, yeah.
They're all driven by experts. You have to have experts to even begin the case. Before you can even begin the case, you have to have experts review the case. So they are wildly expensive. And that's just the way it is in Florida. So we could do a whole show on those.
Oh, yeah, for sure. That's why I figured we should at least touch on it. Maybe next show, you and I can dive into that when we come back together again. But I love to do a current event before I close out the show if we have something in the news that we can talk about. And I just want to touch on it because I'm sure our listeners may have heard about it. It's been in the news, the Disney Extreme Wedgie case. I wanted to get your thoughts on it. This young lady, she went to Typhoon Lagoon and got on the Cowabunga water slide, a 214 feet high slide in which her lawyer alleges that the Disney should have known of the risk of painful wedgies, particularly for women. And she has filed suit in Orange County because of a women's anatomy. The risk of painful wedgie is more common and more serious than it is for a man. The suit alleges that Disney was negligent and breached its duty of reasonable care in failing to provide protective clothing, such as shorts, for the slide, and failing to warn the plaintiff or other women of the risk about the design and the safety failures. What do you think about that, Brian?
I think they have a case. And the reason I tell you that is because it's been known for a long period of time, for example, with jet skis or wave runners, whatever you want to call them. Unfortunately, women have fallen off the back of those and unfortunately had water forced into anatomical openings at high speed, and it causes severe damage. So the question in that case is going to be whether or not Disney had superior knowledge that this could occur, and did they fail to warn it? And chances are, when you do the discovery, they'll probably have had past incidents where people have complained of that, and they probably had some knowledge of it and failed to warn about it. And that is going to be key because, actually neoprene shorts are recommended for riding wave runners, and it's a very, very similar type of accident. So I think that case, more likely than not, has merit.
Good. Well, that concludes our show, folks. It is FLA Law on the radio. We are done for the night. We'll see you back next Tuesday at 5 o'clock.
WTAN, Clearwater.
FM 106.1.
WDCF, Dade City.
FM 102.3.
Listen.